I'm Bryan McHale. I am an employment law lawyer with Bow River Law. We are located in Calgary, Alberta. I'm going to answer the question, what terms should be included in an employment contract? Now, of course, I'm focusing on a written contract. You don't need something in writing in order to have an agreement between the parties. There's a Latin term called consensus ad idem, a meeting of minds. And that's really what we're talking about. We're talking about two individuals, two entities coming to an agreement as to their expectations and their responsibilities between each of them. That's what you want your contract to include. We often use the word fundamental or essential terms. So these are terms that are very important. They define who the individuals are and what their obligations are to each other. So what is your name? What kind of contract will it be? Will it be a fixed term or will it be an indefinite term? Then there's the compensation. These are all essential terms. Salary, bonus, benefits. Is there a signing bonus? What about allowances? And then there's the obligations between the two, responsibilities. What's the title of the employee? What will be their job duties? Now, these don't have to be an exhaustive list, and some of these terms can be supplemented in policy. And as I said, you can also have an understanding or agreement on terms that aren't within the written agreement. I mean, the benefit of a written agreement is the parties now understand what they are supposed to do and what will happen when the relationship ends. That's a key element to the employment contract. Termination clauses. These are found within an employment contract. The purpose of that is to give clarity as to what the employee and the employer understand will happen upon termination of employment. In truth, termination clause's primary purpose is to limit the employee's reasonable notice at common law. Not in all cases, but most. One critical thing to understand in the employment relationship is that there is an unequal bargaining power between the employer and the employer writes the agreement, gives it to the employee signs it without question. That's normally how it works. Because of this imbalance, the courts have recognized that the employees can be vulnerable. And in Canada, we have these implied contractual terms. These are terms that are put into the agreement, whether they're written down or not. These come from common law. They also come from statute. It's also important to understand what law applies. Is it Alberta, Ontario, British Columbia, or the United States? This will help interpret the contract in case there's a misunderstanding as to what the contract says and how it should be applied. Again, the main reason for employment contracts is to understand the expectations between the parties, the responsibilities of each, and what happens when that relationship terminates or breaks down. Some of the things that you may want to include are things addressing the employer's proprietary interests, confidentiality, non-solicitation, non-competition. When you talk about the essential terms, you're talking essentially like, who are the parties? What is the purpose of this agreement? Well, it's to provide services to the employer. Or what am I being paid? What's included in my compensation? What is the employee's responsibilities primarily? These are elements that should be included in the agreement so that there's a basic certainty and understanding between the parties. At the end of the day, the parties have a unique relationship, and time and cost permitting, each contract should be written individually for each situation. I recommend speaking to an employment lawyer, both if you're faced with an agreement as an employee or if you are drafting a new agreement as an employer. Thank you.